Section 26. Lombardo Court Case Introduction. When confidentiality and disclosure collide. Throughout this course, we have discussed agency duties, fiduciary obligations, disclosure requirements, and the responsibility agents have to deal honestly and fairly with all parties in a transaction. One of the most difficult situations a buyer's broker may face occurs when confidential information about a buyer conflicts with information that may be important to a seller. Can a buyer's broker keep financial problems confidential? Does a buyer have a duty to disclose information that may prevent them from closing? Can a buyer's broker be held liable for failing to disclose information about a buyer's inability to perform? These questions were addressed by the Arizona Supreme Court in one of the most important agency cases affecting Arizona real estate professionals, Lombardo versus Albu. The decision significantly impacted how agents view a buyer's ability to perform and clarified that certain financial information may not be protected as confidential when it directly affects a buyer's ability to complete a transaction. The failed transaction that started it all. The case began with a difficult financial situation. The Lombardos were homeowners facing foreclosure. They had defaulted on a second position deed of trust secured by their home, and the lender had initiated foreclosure proceedings. In an effort to avoid losing the property, the sellers entered into a workout agreement with the lender. Several months later, buyers expressed interest in purchasing the property. The buyers were represented by a buyer's broker. During the transaction, the buyers disclosed to their broker that the husband was experiencing significant financial difficulties. Believing financing could still be obtained through the wife alone, the buyers submitted an offer in only the wife's name. The buyer's broker did not disclose the financial concerns to the sellers. The sellers accepted the offer and entered into a purchase contract contingent upon financing. Unfortunately, financing never materialized. The buyers were unable to close. The foreclosure proceeded. The sellers lost the property. The lawsuit begins. After the failed transaction, the sellers filed a lawsuit against multiple parties involved in the transaction, including the buyer's broker. The sellers argued that had they known about the buyer's financial difficulties, they would have negotiated different contract terms or continued marketing the property to other buyers. The trial court ruled in favor of the buyer's broker without ever conducting a full trial, concluding that the buyer's broker had no legal duty to disclose the buyer's financial information. The Court of Appeals agreed. The reasoning seemed straightforward. Financial information was considered confidential. A buyer's broker owes fiduciary duties to the buyer. Therefore, disclosing adverse financial information would violate the broker's duty to the client. For a time, it appeared that the buyer's broker had no obligation to disclose the buyer's financial problems. The Arizona Supreme Court sees it differently. The Arizona Supreme Court disagreed with the lower courts. In a landmark decision, the court reversed the prior rulings and held that information regarding a buyer's ability to perform may not be treated as confidential when it is critical to the transaction. The court explained that buyers and sellers owe duties of good faith and fair dealing to one another. A buyer cannot present themselves as a ready, willing, and able purchaser while knowing there is a significant risk they will be unable to complete the transaction. The court stated that parties to a contract must disclose material facts affecting performance. A buyer who knows there is a substantial likelihood they cannot close the transaction has a duty to disclose that information. Because the buyer has that obligation, the buyer's broker may also have a duty to disclose information that makes performance unlikely. This decision changed how many Arizona brokers viewed disclosure obligations. What does ready, willing, and able really mean? Throughout real estate history, brokers have often used the phrase ready, willing, and able buyer. Most agents understand that a buyer must be willing to purchase the property and prepared to proceed with the transaction. However, the Lombardo case focused heavily on the word able. A buyer who lacks the financial ability to complete the purchase may not truly be a ready, willing, and able buyer. The Supreme Court emphasized that a buyer cannot knowingly enter into a transaction while concealing facts that make closing unlikely. Doing so may violate the duty of good faith and fair dealing that exists between contracting parties. The broker's duty to deal fairly. One of the most significant aspects of the Lombardo decision is its discussion of a broker's duty to parties other than their client. Many agents believe their only duty is to protect the client. While fiduciary duties certainly exist, Arizona law also requires brokers to deal honestly and fairly with all parties to the transaction. The Supreme Court relied upon legal principles contained in the Restatement Second of Agency and concluded that a broker may be liable if the broker knows facts making performance impossible and fails to disclose them. This does not mean buyer brokers must disclose every detail about a buyer's finances. It does mean they cannot ignore information that makes successful performance unlikely. Real-world example: the buyer who lost their job. Imagine a buyer enters into a contract to purchase a home. 3 days later, the buyer loses their job. The buyer informs their agent, but asks the agent not to tell anyone. The buyer still hopes to obtain financing, although the chances are extremely low. Should the broker remain silent? The Lombardo decision suggests the answer may be no. Information that significantly affects the buyer's ability to close may need to be disclosed because it directly impacts the transaction and the seller's ability to make informed decisions. The Commissioner Rule question. One of the issues raised during the case involved an Arizona Department of Real Estate Commissioner's rule requiring disclosure when a buyer may be unable to perform. The sellers argued that violating the rule should automatically create civil liability. Interestingly, the Arizona Supreme Court declined to answer that question. Instead, the court found that common law duties already required disclosure under the facts presented, and therefore did not decide whether a violation of a commissioner's rule by itself creates a private cause of action for damages. As a result, that legal question remains unresolved. What Lombardo means for today's agents? The Lombardo decision remains important because it reinforces several key principles of agency law. Buyers have a duty to disclose information that materially affects their ability to perform. Buyer brokers cannot automatically assume financial difficulties are confidential. Agents must balance fiduciary duties with the obligation to deal fairly and honestly with all parties. The duty of disclosure extends beyond property defects and may include information affecting a buyer's ability to close. In today's market, this often means encouraging buyers to obtain strong loan approvals before submitting offers, and promptly addressing any significant changes to the buyer's financial condition during the transaction. The big lesson: the Lombardo case teaches that agency is not simply about protecting your client at all costs. Agency also requires honesty, fairness, and good faith. A buyer's broker cannot ignore information that makes performance unlikely simply because the information may be uncomfortable to discuss. Buyers and sellers both rely on the integrity of the transaction process. When material information affecting performance is concealed, everyone is placed at risk. The best agents understand that disclosure and fiduciary duties are not competing obligations. They work together to create a transaction environment built on honesty, trust, and informed decision-making. The Lombardo decision remains one of Arizona's clearest reminders that successful agency practice requires balancing loyalty to the client with fairness to all parties involved in the transaction. Online discussion questions. Question 1. Why was the Lombardo case important to Arizona real estate agents? Answer. The case clarified that information affecting a buyer's ability to perform may not be considered confidential and may require disclosure to protect the integrity of the transaction. Question 2. What duty did the Arizona Supreme Court emphasize in the Lombardo decision? Answer. The court emphasized the duty of good faith and fair dealing that buyers and sellers owe to each other during a transaction. Question 3. How does the Lombardo case affect buyer brokers today? Answer. Buyer brokers must recognize that information making a buyer unable to perform may require disclosure and cannot automatically be treated as confidential.